With that, I would like to introduce Tim Gartin. Everybody knows Tim. Tim is a partner in the Ames law firm of Hastings, Garten, and Betcher. He's got a general practice that includes, but is not limited to, real estate. Tim graduated with a BA from Iowa Wesleyan, and he has an MA from Iowa State, and his law degree is from Northern Illinois University. Tim's a member of the Story County and Iowa State Bar Associations. He has been chair of the real estate and title law sections, and he is a fellow of the American College of Mortgage Attorneys. So, without further ado, but I would invite anyone in the back. We have some scattered chairs. If you'd like to get comfortable before Tim starts, now's the time. With that, I'm going to introduce Tim.
Okay, great. Well, thank you, Linda, for the introduction. And I have to tell you, on the front end of this, my kids are really nervous about this. They were talking to me, okay, you're going to Des Moines to do what today? And how long is this going to be? Like, they shook their heads like, wow, we sort of feel sorry for those people. But I'm like, no, this is going to be really fun. So here's sort of big picture what we're going to do today. This is sort of a dream come true for us to have a 3-hour block of time to really go deep and talk about title examination. A lot of the seminars we have are for particular areas of title law, and this is one of the few we've done in a long time that's really asking ourselves the big picture questions. What are we doing when we pick up that abstract? And but before I get too far into this, I wanted to echo what Linda said and give a word of thanks to our title guarantee people. I'm getting a little feedback. Are we okay? Okay. So I'm going to ask the title guarantee people to stand up one more time. I really, really appreciate all that they do for title law in Iowa. So can we give a round of applause for all the title guarantee people? You guys are rock stars and a big part of what we do. So, some additional rules here. I got to figure out where I can stand today. Some of you are new attorneys. Some of you have been practicing law for a really long time. And for those of you who have got quite a bit of experience, let me invite you in to add your comments, your questions as we go through here. I really envision this to be more of a dialogue and a collaborative effort than a monologue. And so take me up on that. Several of you have already talked to me about things. Hey, Tim, be sure to mention this or that. Feel free to jump in and throw those comments out. Now, I'm also curious to know how many abstractors we have here. If you're an abstractor, let me just see where you are. We have a great representation of abstractors. So thank you for your investment of your time here today. I hope it's helpful for you to lean in and hear what we do once we get this abstract that you've given us. And then how many lawyers do we have? Okay, quite a few lawyers. Good. All right. And I'm curious, of those lawyers, how many lawyers have practiced law for less than 5 years? Just to give me a sense of who's here. So a little higher. We won't. So you're trying to. No. Just give me a sense. Okay, thanks. All right. Any lenders here? No lenders? So I can tell all kinds of banker jokes and things today without. No. So feel free to jump in as we go along today. With respect to questions, one more comment. Some of you have the capacity to ask a question that would take an hour to really work through. So do a little self-filtering, and as you're thinking about questions, think about questions that would be helpful for the kinds of topics that we're talking about today. A little bit lower level, entry level, beginning abstract work, and so do a little self-filtering. If you ask a question that is just beyond the scope, I may say, that's a great question. Let's visit about that during the break or afterwards. So because this is being videotaped, we really want to maximize the time we have on our target audience. Okay, so big picture. And before I get too far, how is the sound? I'm getting a lot of feedback. Jim, are we okay? You're okay. Are you getting feedback? Okay. Okay, so bear with us for a little bit as we work out the technical aspects of this. So let's talk big picture. we need to start off thinking about the role of title insurance and secondary market loans. So if you're going to buy a house and the lender is going to make a loan to you that is going to be sold on the secondary market, there are several boxes that have to be checked. Underwriting is a big issue. In fact, it's gotten a lot harder. There was a time when if you could walk and chew gum, we'd give you a loan, right? We wouldn't care if you could pay it back or not. Underwriting standards have really been improved, I think, in the last few years. The lender is also concerned about the value of the property, and so there's an appraisal that's done. Lender wants to make sure that this property has the value to back up the loan that's being made. But the third leg of this stool is they want to make sure that the title to the property is in order so that their mortgage is in first position. That's all this is about in terms of the title work. If you're dealing a secondary market loan for a lender, is making sure that worst case scenario, if the wheels fall off, the borrower defaults in the loan, the lender forecloses, their mortgage is in first position. That's really all that they care about. And why this is important is because I think a lot of attorneys who are examining abstracts but they're not closing them, I think there's a bit of a disconnect sometimes. They really don't understand what's all this for. And it has the purpose of making sure that these mortgages have first priority status against the property. So where does title guarantee fit into all this? Well, as the secondary market developed, 70s and 80s, there was a recognition that there was going to be a need for some kind of title insurance product. And there were some people that had a lot of foresight and said, look, either all the premiums that are being generated from these policies can go out to New Jersey, or we can keep them here in Iowa. Now, no offense to New Jersey, but I really like the idea of keeping this money in Iowa. But not only do we have the concerns about the money, the other driver of this was the quality of our title. And so this idea of working with our existing structure of abstracts and attorneys examining abstracts came about, and working with Title Guarantee came up with the products that we had beginning in the mid-1980s. And I'm here to tell you something that's very encouraging. If you don't already know this, Iowa has the cleanest title of any state in the country, and at the lowest price of any state in the country. We have the best of both worlds. And folks, I'm really proud of that. I'm almost tempted to lose this. You're going to fix it? Okay. All right. I'm going to say keep it on for a little bit. And so I'm very excited about this product that we have. Now, one of the challenges is Iowa's 2% of the population, and we have a system that is in some ways different than much of the rest of the country. So our underlying product, this Alta title policy that eventually is going to be issued to accompany this loan, is going to be actually a better product than what many states have. The underlying process of how we get there is going to be different. It's good for you to understand the background of this because you may find yourself talking with out-of-state lenders trying to explain how Title Guarantee works. And you can always redirect them to the Title Guarantee website or Title Guarantee staff. They're also helpful in sort of holding hands in that situation. So that's sort of the big picture of the role of Title Guarantee. Now, attorneys and abstractors, we play a very important role in this. And I'm so glad we have so many abstractors here. We rely heavily on the quality work that you are doing. This whole system wouldn't work unless we had abstractors who are doing the kind of quality work that we have here in Iowa. So I love abstractors. Okay? Attorneys then need in some ways make sure that relationship is real solid. As we talk today, I'm going to talk about the substance of what we do as examining attorneys, but it's just as important to me. I want to talk about the attitudes that we have in working together. I want that to come out today, so lean in on that stuff too. Okay, so preliminaries to examination. One of the questions that the examining attorney has to think about first is who are you examining for? Okay? The vast majority of your title opinions are going to be for a lender. And so that is a very different mindset than if you're examining for an individual on a cash transaction. And a case that you should all pull if you're examining attorneys and have in your three-ring binder of important real estate cases is a case I cite there, the Basil versus Rhines case. And that's a case that actually doesn't involve attorneys per se. It deals with realtors. And it deals with the standard of care that a realtor was to have when advising their buyer clients about restrictive covenants and the number of dogs that could be kept in a particular subdivision. Well, this analysis is important because I think if you replaced realtor with lawyer in this case, you get exactly the same outcome. That the attorney examining for the cash buyer would have a duty to say, oh, what do the restrictive covenants say for your intended use of the property? So when I'm examining for an individual, I want to ask them, what do you want to do with this property? Are you going to put a daycare in there? Well, there might be some covenants. Do you plan on doing some construction? Well, we want to think about what are the limitations that this property has with respect to the ability to build on that property. And so our mindset needs to be dialed into whether we're examining for a lender or examining for a cash buyer. Okay, well, let's shift over to the outline. Now, this outline is what I use when I speak to newer attorneys at the Iowa Bar Association Nuts and Bolts presentation every fall. And so there's some material here that is sort of bonus material. And we're going to sort of skip over this introductory material. Some of it I hope is helpful. And start with the overview of title examinations on page 5. If you wonder why this thing is so big, I love forms. And I love to go to seminars where they load me up with forms. And so I went through my form library and went through and pulled out all the cool forms that I thought you might benefit from. And so they're there in a pretty big appendix in the back. Well, let's start talking about title examination. So Title Standard 1.1 is really where I want to start. And I promise not to read too much today, but this material we really want to focus in on. Bottom of page 5. The purpose of the examination of title should be to secure a title for the examiner's client, which is in fact marketable and which is shown by the record to be marketable, subject to no encumbrances other than those expressly provided for by the client's contract. Objections and requirements should be made only when the irregularities or defects, and this is where you can start underlining, can reasonably be expected to expose the purchaser or lender to the hazard or adverse claims or litigation. To render the title to land unmarketable, again, underline this part, there must be a reasonable probability of litigation. The mere bare possibility or remote probability that there may be litigation with respect to the title is not sufficient to render it unmarketable. That's really important. And so one of the challenges as a newer attorney is that you don't know what kinds of objections are going to expose that property to litigation. As a new attorney, I remember examining an abstract in one of my first title opinions. It looked like a law review article. I may have even had footnotes. I mean, it was well documented. I had authority. It was brilliant. And back then we had these things called fax machines. I don't know if you know what those are. I faxed the title opinion out to everyone. And about 2 hours later, I get a call from one of our senior attorneys in Ames. And the conversation went something like this. Mr. Gartin, I know that you're a new attorney here in Ames, and I appreciate the thoroughness in which you composed your title opinion. But I don't believe this objection rises to the level of exposing this property to any kind of litigation. Bummer. It was brilliant. And so you don't know when you're starting out, is this something that's really a problem? Or is it just something that I should make a note of and go on? The analogy that I sometimes give is, back in the day when we actually had pheasants in Iowa, I would go pheasant hunting. And when the bird is flushed, sometimes you don't know right away whether it's a hen or a rooster. Right? And you're tempted to shoot. And you're relying on, and sometimes your friends to say, hen, don't shoot it. Right? And sometimes that's a situation as examining attorneys We're tempted to lock and load and pull on that bird, but it's really not a rooster, and we shouldn't raise objections. And when we raise objections that are not properly made, what we do is we just make a mess of things. It drives lenders nuts, it drives realtors nuts, and it makes the argument for title insurance far more appealing, because in title insurance states, they don't care about these problems. They just insure over them. In Iowa, we actually bother to clean these things up. Right? And so we want to make sure that if we are going to raise an objection, we do it in a situation where it's really warranted. Okay, so anatomy of an abstract. So some of you have really not seen abstracts before if you're new attorneys, and I just brought one for show and tell. And it's a collection of entries that are the sum of a lot of hard work of abstractors. They went through our court files and our county records, going through all these stacks and stacks of documents to reduce them to entries that an attorney can examine. Okay, legal descriptions. This is an important subject. We can't screw up legal descriptions. Where we're dealing with legal descriptions that are meets and bounds, and meets and bounds is basically surveyor talk. Right? We're going to describe a property with the way in which a surveyor would identify the location of that property. It's imperative that we not screw up the meets and bounds descriptions. And so in our office, we have a rule that if we have a meets and bounds description that we have to retype, we always read that to somebody else. So the accuracy is important. Some of you have computer programs where the computer program, the word processor, will read to you. Great. Do something where you're double checking that. Now, if it's a meets and bounds description that's just monstrous, and some of these are just horrible, aren't they? I asked the abstractor to email me that legal description, and they always do that because the last thing we want is to screw up someone's deed and mortgage and have to re-record and do affidavits to correct things. So we want to make sure that's correct. Now, one of the other things that's important about a meets and bounds description is we want to be able to connect the dots. And so as a new attorney, my senior partner gave me this horrible legal description and a piece of graph paper and say, I need you to draw this thing out. I thought, what are you, nuts? This is crazy. And so I sat down and I figured out how to read this surveyor language and draw the thing out. And so one of the things I suggest that you do is learn how to draw this out. Now, in your materials, you have an example of a piece of graph paper that you'll use for drawing out a meets and bounds description. Now, along with that, I will tell you a little hint. If you have the meets and bounds description from hell, remember the assessor site has a map of that property, and that can be very helpful. So if you have a property and it is in the shape of a donkey, who knew you could have a property in the shape of a donkey? You can actually see, yep, there it is. It is a donkey. I can't believe it. It's really a donkey. And so use that as a trick to help sort of double check your work when you're drawing out that meets and bounds description. Now, as a general rule, what I want to say too, sometimes you have the choice of using a plat of survey description or a meets and bounds. Guess which I'm going to recommend? The plat of survey. So simplify, simplify, simplify. The shorter the legal description, the less likelihood of a screw-up. Right? So always try to work with people. If you see an abstract and there's a meets and bounds description, but there's also a plat of survey, say, look, let's use the plat of survey. Let's make this as simple as possible. Okay, pencil notes. Pencil notes are really not an abstract. It's a collection of the documents that will eventually be incorporated into the abstract. It's sort of a phenomenon here in the metro area. And my guess is that eventually pencil notes will go away. Because applause is warranted. I have to be careful. This is going to be on videotape. Can they edit this part out, Jim? No? So right now the trend is towards, at closing, being able to give that abstract to the buyer when they leave. I don't want to send this abstract back to the abstractor. Final abstracting done, it comes back to me. I do my part, then I can get it back to the buyer. Why do that? So now the trend is the abstractor records the deed and mortgage. They send me the final abstracting. I do my thing, issue the policy, and we're good. The abstractor is already with the buyer safe and sound in that lockbox or fire safe or under the bed. right? Where it shouldn't be. Taking notes. Okay, so there are different schools of thought on how to do this. So find in your notes, there's materials. There should be a set of notes. Maybe it's in the back. It's in the front? Okay, thanks, Jerry. So lawyers will differ on the way in which they take notes. I'm not married to this approach to taking notes. So if in your office they have a different style and different approach, totally fine. I'm going to show you what I do when I take notes. And this is really critical as far as understanding this. So at the top, I'm identifying my client, who the borrowers are, the date, legal description. And the way that I do this, I indicate who did the initial abstracting and who did the final abstracting, just to sort of memorialize this abstract. So it was initially started by this, and then subsequently continued to this by this abstract. So what do I do when I examine this thing? What am I looking for? Do I have to start at the beginning? Why do I go through all this page by page? So an abstractor has to show a 40-year chain of title for the property. But there are some things that occur out there that are beyond 40 years that we still have to show in our title opinions and in our abstracts. Any ideas what those are? Easements. Yeah. So you could have an easement for access across that back corner of the farm that's 100 years old. And that would still have to be shown in the abstract and in your title opinion. So when I'm examining, I want to find that 40-year chain of title point, but I'm actually starting at the very beginning and going through, because I'm looking for things like easements, and that's principally what we're looking for, easements that could be older than 40 years. So I'm indicating there, we're going to go through this line by line. Here's the plat where there's the dimensions shown, and then there is an easement, and I'm indicating in my notes the recording information for that easement, and then I'm showing the chain of title of these different... This is sort of interesting. They're all presidents. That's weird. Okay. And then we come to some mortgages. And so what I'm doing with the mortgage is I'm indicating the book and page, or if you're in a county that uses instrument numbers, and the recording information. And I put a little star next to that entry. And that star is an indication to me that that's something that's going to go in my title opinion unless I come back and show it to be resolved. So there's a couple mortgages. There's an assignment of that mortgage. There's the title then to Dwight and Mamie Eisenhower. And then there was a mortgage to Wells Fargo, and I'm indicating the amount. And then I go along here, the Eisenhower's divorce. I never knew this. So there's a dissolution of marriage. And I'm indicating Dwight owed some child support. And I'm actually doing a calculation. So in this particular entry, the abstractor provided me with the payment information. So I actually went through the calculation, figured out how much Dwight owed, and how much Dwight paid. If the child support is current, do you have a lien? No. Child support is only a lien if it's unpaid. Right? So if I can do the math and I show it's current, there's no lien. So I put that in my notes. And then I had a little typo or a little mistake when I wrote this out. I made a note here: the decree, real estate to Dwight, Mamie to give quitclaim deed is what it should say. All right, next page. Then entry number 76. Conveyance from Mamie, single person, to Dwight. There's another mortgage here now to Wells Fargo. And then there is a release. But there's a problem with this release. The release is from our friends at MERS. Imagine a screw-up from MERS. They don't send me Christmas cards anyway, so we're beyond this now with MERS. And so there's a problem with this release. And so I made a note here, requirement, an assignment, or a proper release. And so I go back to the entry number 71 and I make a notation, see entry number 82, because I want to make sure I connect the dots. Then I show restrictive covenants. No automatic renewal. I always am looking for with restrictive covenants, and we'll talk about this in more detail, whether a set of restrictive covenants have a provision that provide for automatic renewal. Folks, this is huge. And so if you're examining an abstract and it provides for one of these goofy automatic renewals, you need to point that out because it's unenforceable in Iowa. And this is going to be a big issue as time goes on, unless we make some change. Zoning, taxes, and then I make a note of the lien search. Then on the bottom, I write issues for title opinion. Now I've got the mortgages. I know I'm going to look for the mortgages, but I'm making some special notes. And why am I doing that? Because I might get interrupted. There may be a time break between when I examine the abstract and when I actually sit down to type, and I don't want to screw this up. And so I go through here, when I decide what's going to go in my title opinion, I circle those stars, and I say, I have to have this in my title opinion. So there's the dimensions, there's the easement, there's that mortgage that wasn't properly released, there's the reference to the second mortgage, and I've got the defective mortgage release and the child support. I've got to make sure I get that child support in there. Now, you may say, well, Tim, why are you going to put a note in there about child support? I thought you said it was current. So one of the things that we do when we take our notes is sometimes we put things in title opinions that might be objections, and we explain why they're not. For example, with child support, the child support is current through November. What if this doesn't close till December or January? There still needs to be a showing then. So we want to give the bank or the closer a heads up. Hey, just to let you know, Dwight owes child support, and you want to make sure that's current by the time you get to the closing. It's also good to make notations in there. Let's say 5 years from now, someone else examines this abstract, and they raise a title objection that you did not put in your title opinion. So I think it's very powerful in the title opinion to raise certainly the things you have to raise, but there are some things I put in that title opinion I don't really have to from the lender's perspective. I do this because I want to make sure that if an issue comes up later, I've documented the authority for why I waived that objection. Right? I like that in a well-drafted title opinion. Okay. Questions on the notes. Some of you have very different approaches. I've seen approaches with columns where you're sort of tracking along with things. Yes, in the back. Yeah, so the question is, what do you do if the child support record isn't shown? And we talked about things when an attorney has to look beyond the abstract. And that's oftentimes one of them. So if that's the case, then I will go ahead and show the objection. And then about a day later, I will get a fax of 20 pages of child support records, and I have to go through and I have to add these things up. I don't know any way around it. There are some counties in Iowa where the standard is they just require a child support receipt regardless. And I don't do that because I don't want to burden the process, the transaction with costs they really don't need to have. So I'll take a few minutes. I'll go through the calculations. It's really not hard, but sometimes you have to go outside the abstract. Yes. So the question is, what do you do then in terms of memorializing in the abstract? And so that's oftentimes done. It's a good strategy. Is as the attorney, you just write a simple affidavit saying you review the child support payments, and it appears that the obligation is current. Thanks for raising that question. Other pointers or experiences on notes. Does anyone do anything radically different? I'm just curious than this kind of note taking. No? So it should be something like this, right? Don't get married to the form. I show this more from the standpoint of what your goals are, the kind of attitude you're having. It's always fun when I teach someone in our office how to examine abstracts. When you start, you take notes on every entry, right? I love those. Here's 10 pages of notes, and most of it is irrelevant. But when you start out, you don't really know what's relevant. And so you err on the side of putting too much in your notes. I understand that. And over time, then, you figure out, actually, that conveyance from 1897, I don't really need to have that in there. Don't really need that. Okay. All right. This 40-year chain of title is something that we always have to keep our eye on. And one of the areas that oftentimes gets missed are situations when you're adding a little strip of property. It might be a vacated alley, right? Or maybe some strip that somebody bought from the neighbor. And you want to make sure there's a 40-year chain of title on all of the real estate that's being added. Now, as a little practice pointer here, too, I talk about this with respect to situations of alleys. So we have a lot of small towns in Iowa that when they laid them out, they had all these alleys. And so at some point, that alley's growing grass. It never really amounted to anything in terms of a road. And so eventually the municipality says, hey, let's just divide this and convey that back to the adjoining property owners. Well, there's a certain showing that has to be made, and I talk about that there. Okay. Some of this I'm going to skip. One comment on this issue on top of page 8. Every once in a while I come across an abstractor who will exclude roadways in their caption of their abstract. And the idea being that we don't want to show any judgments against lien holders. And so if there was a lien against the county, then we'd have to show that judgment because it's a judgment against a lien. I want to say this as lovingly as I can. That's wrong. Judgments do not attach to easements. And so the problem with providing an exclusion for roadways, for example, is that some attorney, not understanding what you've done, is going to take that caption and use it for the legal description of the deed. And they're going to improperly exclude that roadway, which wasn't created by conveyance, it was created by an easement. So Mr. and Mrs. Smith, who are now living in a retirement center in Florida, they own a little strip of roadway in front of their house. Who knew, right? So that's a problem. So keep your eye out for that. Every once in a while you'll come across a situation where you see the caption of the property, and they're searching everything except public highways. And that's fine if the public highway was actually created by a conveyance. But if it was only created by an easement, then you've got a problem. Yes? Yeah, you can say subject to the, if the question is if the language on the caption is subject to the easement, is that okay? No problem. It's the excluding the public highway. That's the real problem. And let me take it to its ultimate conclusion. You do a loan for Mr. and Mrs. Smith, and their purchase of the property. The lender has a mortgage against the property. It's foreclosed. The legal description of their mortgage is going to be the legal description of what they get at the end. And it's going to exclude that strip of property. And so we want to make sure we have an accurate sense of what that property is. And so watch out for that exclusion of roadways. I think that's going to go away over time. Okay, writing in abstract. Oh, yes, sir. Yeah, so the question is, let's keep our legal descriptions even tighter and not reference these easements at all. And I agree with that, but here's the one caveat. Sometimes easements are created in very goofy places. So let's say the easement was created by a deed. So I'm conveying my real estate subject to an easement so I can access this corner of the property. Well, an attorney flying through this abstract at 2 o'clock in the morning may cruise right through that easement, and it might be very important. So there are some isolated places where I think that heads up as an abstract that you can give to the examining attorney can make a lot of difference. So thanks for raising that point. So what about writing in abstracts? Every once in a while I see an abstract come my way, and the lawyer is taking all these notes on it. I'm like, what? What is that? So in my office, I don't think I should stand there. Sorry. So what I think we should do is the only reason why an attorney should write in an abstract is, for example, circling, for example, a lot. So let's say you've got an easement and you have 20 different lots that are referenced in this easement. I think circling that lot number just to give future examining attorneys, oh yeah, just to help you out here, here's that lot number. I think that's okay. But generally, if there was a mistake in an abstract, let's say you have a situation where there was a wrong instrument number in a release. I think the proper thing to do is to call the abstractor and say, hey, I found that. And you know what I found with abstractors? They love being notified about that. And they'll send over that replacement page just like that, and no one knows the difference. Right? So the attorney who takes the big pen out circles this. Wrong! That's not helping anything. Right? Okay, so try not to write in abstracts. An important point, too, here is what legal description to use. Sometimes a legal description will change over time. And so there's a temptation to just take the caption from the cover of the abstract and use that for your title opinion. That can be a terrible mistake. So the caption that you want to use for your title opinion is the caption at the last continuation. That's what the abstractor is certifying. So you want to keep that in mind. Sometimes property is added, subtracted, so keep in mind it's the legal description from the last continuation. I think it's important that you develop an abstract log. And this is a little side note. In our office, when an abstract comes in, we create an abstract log. And you better never take an abstract out of my office without this log on it, because the secretary will have your hide. So we have an abstract log that goes back some 50 years, and we can tell whenever an abstract came into our office or left. We know exactly when it came in and when it went out and to whom it went out. Because inevitably there will be an abstract that will be lost that at some point you had your hands on. And they're going to be asking you to contribute to the cost of rebuilding this abstract. And you want to be able to say, well, on August 4th, 2003, I gave this abstract to John Doe. Sweet. And so having some kind of computer-based log where you can pull that up quickly is of great help. A lot of other practice pointers. I do think it's important to have a copy of the title standards close by your desk. We'll talk about resource materials later. I like using a 3-ring binder because occasionally I will come across a case or other authorities that I want to throw into my title standards. So I have all that stuff nice and neat there on my desk. Okay, let's start talking about the title opinion forms. Top of page 9. Really important that we remember who we're writing our title opinions to. The people who are reading our title opinions are not your law professors. Okay? They're lenders, they're realtors, and they're wanting to know one thing. What do I have to do to get this property to closing? Right? So remember your audience. So sometimes I see title opinions. You really can fall in one of two ditches. You can have the title opinion like I wrote when I was talking about one of my first title opinions. It was a law review article because I wasn't really thinking about my audience. Right? You'd have to go to law school to have really appreciated my title opinion. But there's another ditch over here, and you can say so little about an objection, and that's not really helpful for clearing the objection. A couple weeks ago, I saw a title opinion where the attorney said, entry number 47 has a judgment. It must be released. Oh, thank you. That's very helpful. You mind telling me what that is? Right? So you want to provide enough guidance in your title opinion to help with that. And if you have sort of a quirky type of objection, then I think it's really important that you lay out some different steps. Here are some things you can do to resolve this. So it may be it's talking about the title guarantee mortgage force-off program, or steps that you would take to get a corrective document. Give some advice. So put yourself in the recipient's position of this title opinion, and is there going to be enough guidance for them to be able to do something with this? Right? I know that sounds fundamental, but I see enough of these title opinions come across my desk where that obviously wasn't in the attorney's mind when they drafted that title opinion. So be generous with suggestions about how to address title defects. Okay, let's take a look at my form, and that is over '51. Thank you. Page 51. So the title opinion structure, I think, should be well organized to help people to navigate what it is you're talking about. Now, there are still some attorneys, and they don't attempt to try to organize the title opinion. It's just numbered paragraphs, 1, 2, 3, 4, 5, 6, 7. And the problem with that is that the recipients of this, what they're going to ask, first of all, what are the mortgages? Okay, do we have some mortgages on here? Because I got to know. I got to get payoffs. And then, are there any judgments? Okay, judgments, anything I got to correct? So in the mind of the audience, there is a priority of what's important to them. So you can see that's how I've laid out this title opinion. So let's take a look at it. So I've got the caption of the legal description, the abstract information about who's prepared this abstract, title to the real estate, and then and this is on page 52, the standard now is to show a 24-month chain of title. I hated this when this came in years ago because it's basically the lender second-guessing us as attorneys as far as who title is vested in. That's honestly what it's about, which drives me nuts. But I'm past that now. And so the standard now is to show a 24-month chain of title. And so I have that as a reference there. You'll notice in number 2, I have some sample language. If it's a single person that's on title, I want to reinforce at that point that the spouse needs to join in conveying that real estate. I want to make it very clear. That's what's a requirement. Some other type of sample language. We'll talk more about trust situations later. Limited liability companies we'll talk about. And then on page 53, this is the sample language for mortgages. So I'm describing the mortgage and also the amount of the mortgage. Now, I have some lawyers that will say, Tim, do we really need to talk about the size of the loan? Does that really make any difference? Because a mortgage for $10,000 is just as much a lien as a mortgage for $200,000. And they're right. Both would have to be released. But I actually think that having the amount on there is helpful. And here's why. Oftentimes, the listing agent they'll done a net proceeds analysis, and they will have an approximate sense of the loans that are encumbering this property, the mortgages that are encumbering this property, loans that have to be paid off. And if you show one mortgage on there for $10,000, and they know, wait a minute, there's a $100,000 loan out there, that may be a help because they may bring to your attention, hey, Rockstar, you missed a mortgage. Right? So putting the amounts on there is sort of a helpful thing because the recipients might be able to help you know whether you missed a mortgage, which is a really scary thing. Next item I want to point out to you is the line of credit bold language. If I could make my title opinions blink, this would be blinking. Right? So this is very important language. And in a moment, we'll talk about line of credit mortgages. But folks, I go out of my way to talk about line of credit mortgages. And you may be thinking, this guy needs some hobbies. He's in need of hobbies. But line of credit mortgages are so critical in this process. We'll talk about this in a moment. Just stay tuned for this. We're going to go really deep. And everyone's going to leave here today understanding the importance of line of credit mortgages. Critical. I'm not going to go through all this line by line. Judgments. You'll see the language I have there. I provide all the information that someone would need to create a remedial document of some type, or bird dog this down. Dissolution of marriages. I show the lien searches on page 54. Okay. Number 3 there. This is something as examining attorneys, you have to decide what you're going to do with this. Beginning in January of 2013, we introduced a very exciting new thing in Iowa called the Mechanics Lien and Notice Registry. It is a wonderful resource that we have here in Iowa for knowing whether there are contractors who are out there that have performed labor or provided material that affect this transaction. It is my opinion that an attorney can play a very helpful role, that at the time of examining the abstract, they can go online, check that property, and add a reference that you searched the MNLR and there was nothing that came up. Now, some lawyers here are thinking to themselves, Tim, I thought you didn't want to go outside the four corners of the abstract. You mean I have to go online? I mean I have to look at this? And the answer is no. You don't have to do that. But it's what I do, and here's why. If there have been contractors out there who have performed work, do we want to wait until the closing to find that out? To get a lien waiver? No. I think it's more advantageous for the closer to find that information out at the time I'm examining the abstract, to give everyone a heads up. Hey, the XYZ company put a roof on this house. You're going to have to get, and they filed the preliminary notice, and there's a commencement of work, and we got to do something about this. Better to get a heads up about that at the time you're examining the abstract than when that contractor's on a fishing trip in Canada. Right? So if you can give a heads up, that's an extra value that the attorney brings to the process. So some attorneys do this and some don't. To complicate things a little bit more, abstractors themselves are not one-minded about what they're showing in their abstract. All abstractors that I've come across since January of this year are all at least doing their standard mechanics lien search. Some are doing searches beyond that just to show commencements and preliminary notices. Some are not. So you want to figure out for the abstractors that you're working with what their standard is. I'm not telling abstractors what to do. Right? It's up to you as abstractors whether you want to do a complete showing or not. It's actually just a really simple click on the mouse. But who said that? It's really easy to do it, but that's up to you as far as whether you want to make that full showing or only show for mechanic liens. Okay? Let's stop there. Any questions or comments on this whole MNLR thing? No? Okay. I thought I was going to make some people mad with that, but I'm okay so far. Because some attorneys really don't like, my senior partner, he and I disagree on this issue. He doesn't go on the MNLR. He thinks, Tim, this is going outside the four corners of the abstract. I'm staying with the abstract. Okay. And so there's not a right or wrong way of doing this. I close a lot of loans, and so part of it is if you're closing the loans that you're doing title opinions for, you think about it a little bit differently. Right? Okay, taxes. Well, that stuff's pretty self-explanatory. Tax sales. I hate tax sales. Whenever I come across a tax sale thing, I just normally just call Jim Nervig, who's right here, and say, Jim, a tax sale, what do I do with this? Legal descriptions, page 55. I think legal descriptions should be legible. Call me crazy. I think it should be legible. If it requires an electron microscope to read the dimensions in the abstract, it doesn't really do you any good. Right? So I'll put some notation in my title opinion if I can't read the dimensions. And we actually had a situation where in this Middle Road developer's case, where the issue of what was on that plat map came out to be a very important issue in this case. And if you haven't read that case, I commend you to read that case. Easements. You want to show easements. We turn over to page 56. We have zoning. Abstractors vary quite a bit around Iowa in terms of what they show for zoning. So in some areas they show zoning, some don't. And then our friends' restrictive covenants. This is the language that I use in my title opinions. They're in the middle of page 56. So again, if the restrictive covenants provide for automatic renewal, then that bold language in the middle, again, I would make that blinking if I could. That's going to show up in my title opinion because I want to put people on notice. There could be a real problem when the Partridge family bus shows up and the restrictive covenants are not in force. Private sewage disposal, that's it. That's the main form. So I use my title opinion form as a drafting guide. Now, I have some provisions that are not going to be on there. And if you turn over to page 62, it's Exhibit 8. I have sort of a library that I won't take you through, but I have a library of paragraphs that I can cut and paste. you're going to want to make your own. And so paragraphs that they don't come up with enough frequency that you throw them in the title opinion form, but they come up with enough frequency that you don't want to reinvent the wheel every time you come across this objection. So you just have a Word file on your computer called sample title opinion paragraphs so that you can take those, copy and paste it, quickly put that in your title opinion very easily. So this is sort of a nice thing to have so you're not reinventing the wheel every time you have to come up with an objection. So you've got a lot of other sample paragraphs that I will occasionally use. Okay, let's go back in the material. On page, back on page 9. We'll talk about organizing the title opinions at the end of our time. We're now going to shift gears and talk about particular issues related to different types of conveyances that are likely to cause an objection. And the first thing we're going to take a look at is partnership conveyances. Now, thankfully, partnerships are on the decline. We just don't see very many partnerships anymore, for good reason. We have so many other better options available. But where you have a partnership conveyance, all the partners have to join in conveying that real estate unless that conveyance is made in the ordinary course of partnership business. Paragraph there talks about that. Corporations. I love corporate conveyances because they don't require any extra concerns. We have a presumption that the entity has the ability to convey the real estate unless, and this is important, you don't miss this, unless there's some kind of showing from a recorded articles of incorporation that limit the authority of that officer to convey the real estate. Right? So this presumption is there is authority unless there's some kind of showing. Page 11, limited liability companies. Limited liability companies used to be treated the same way as corporations. That was a golden age. And then there was a change. The business law section decided that the way in which we convey real estate from limited liability companies needed to differ. And what we did is we changed the model. We moved our limited liability company model statutorily from a corporate model to more of a partnership model. And I could spend a lot more time talking about this. I don't want to go too far into the weeds on this because this is an area of law that's a bit in flux. So we are trying to make some improvements to simplify conveyances from limited liability companies. I've referenced Title Standard 15.3 for your reading. Stay tuned on this. I'm hoping that there are some changes coming down the pipeline. My hope is that eventually we're going to be able to go back to where we were and convey real estate from limited liability companies the same way as corporations. But it's going to be a little while. So stay tuned on that. Municipalities. Sometimes a city is going to convey real estate. And when they do, there are certain statutory requirements of what needs to be shown in the abstract. So there has to be a resolution, there has to be proof of publication, and the resolution following the hearing. So that's there for you there on page 12. I just saw a situation like that a couple weeks ago. Trusts. A lot of people are holding their real estate in trusts. It's very common. We went through a long time where there was a difference of opinion as far as if title was vested in the John Doe Trust, is that a defect? And we changed the statute on this, and so a conveyance to a trust is equivalent legally now to a conveyance to the trustee of that trust, because technically a trust doesn't own anything. The title of the assets is really technically in the trustees. And so we had lawyers sort of fighting back and forth. Well, I think this conveyance was a nullity, and we thankfully changed that. So just bear in mind, if you see a conveyance to a trust, it's okay. The sky is not falling. We have a statutory provision to address that. When the property is coming out of the trust, actually from the trustees, then we have a requirement under Iowa Code 614.14 for an affidavit from the trustee and an affidavit from the grantee in that conveyance. A little side note on this. One of the things you see sometimes is a situation where lenders don't like making loans when there's a trust involved. So, for example, a refinance. And so what they'll say is, look, we want you to convey the real estate from the trust to the individuals. They do the mortgage and then convey it back to the trust. We also have this issue with limited liability companies. And as a little practice pointer on that, there is something you have to keep your eye on. The mortgage is going to have what's called a due on sale clause. All mortgages have it. The reason why, lenders like making the loans to the first person, but they don't want that property sold with that mortgage attached. They don't want someone else assuming that mortgage. And so they have a provision that if you convey the real estate, technically the loan could be called due. And it's very difficult for a lender to waive that due on sale clause. And so you might say, well, Tim, have you ever seen a situation where a lender has called a loan due? And I personally have not. But I was in a seminar a number of years ago. It was over in Iowa City. This question came up, and I threw it back in the audience. I said, have any of you ever seen mortgages where the loan was called due? And they said, yeah. A bunch of older attorneys' hands went up. They said back in the late 70s, early 80s, there were more foreclosures going on, and this was a situation where interest rates were going up, and lenders were calling some loans due. So it's one of those things you want to advise your borrower clients on. It is a possibility. Keep your eye on this if that's a situation where you've got a trust or a limited liability company and they're being asked to convey in and out. The better approach to this, in my opinion, is the use of a certification of trust. The probate code was amended, and I think this is a very good idea from the probate section. They have a certification of trust that indicates the authority that the trustees have to give that mortgage. I think that's the better way of doing this and not worry about this conveyance in and out of the trust. Churches. Churches are funny things when they own real estate. And what we have on this is really the standards out of Marshall's, that it's really more of a standard of prudence. That we want to have some kind of showing that that church went through a process of approving the sale of the real estate. So we're going to ask that church secretary or clerk to sign an affidavit verifying that the church did go through a process of approving the sale of the real estate. I've given you a sample of that. Okay, marital property. Guys hanging in there? Huh? Yes? Yes. No, we typically do not. The question is, do you record the certifications of trust? No. The real impetus for the certification of trust was a lender saying, look, you have a trust. Could you give me a copy of your trust? Like, oh, wait a minute. I don't really want to do that. And so this was done to create a substitute for providing that to the lender when they're going through that process. Thanks for asking that question. Okay. So you're hanging in there. We're going to try and cover, at least get started with marital property conveyancing. Marital status is really, really important. And you can have tattooed to your arm, if real estate or mortgage is being conveyed, every title holder and their spouse has to join in that conveyance. You can just tattoo it to your arm. All right? There are no exceptions. If the marital status was not shown, it is not a defect if that conveyance was over 10 years ago. So then we have a statute that says we have to worry about it. But if there's not, there may be a need for some kind of affidavit to tie up John and Jane Doe were actually married. And so I've given you some samples of that. Sometimes this gets left off of mortgages. In fact, I see this happen quite a bit. Lenders will send me a mortgage to close, and there's no recital of marital status. It's crazy. So as a heads up, always go through that marital status on any mortgage that you're working with.
What do you do in that situation?
Oh, great question.
Do you fix it? Or on your own? Do you call the lender and fix it? How do you handle it?
Great question. Jerry asked the question, what do you do if the marital status isn't shown? And some lenders will tell you that you have no authority to do any changes, make any changes to that mortgage. And I generally buy that, except with marital status. So if there's a typo on a name, I want to make a slight correction, I'm going to go ahead and take the liberty of doing that. But if there's no marital status, I will certainly show the marital status in that mortgage. And I've never been called on this. No lender has said, hey, you screwed up the execution of this mortgage because you showed the marital status. No, I'm doing you a favor because you didn't show it. In fact, understand, if a spouse does not sign that mortgage that needs to sign that mortgage is not voidable, it is void. All Right? That's how critical this is. So that's a call to your malpractice carrier right there. That's scary. So that's a good question. So it's never a bad thing if you see a problem with one of the documents you're working with to call the lender and say, hey, I think you've got a mistake. Do you want me to change it? Do you want to send me a corrected document? That's never wrong to do, but sometimes you just don't have time. You don't have time to get that corrective document. Yes, sir? That is a great question. The question is, can the marital status be handled in the notary block? Yes and no. Good lawyerly answer. We have a title standard that says that if the marital status is shown in the notary section, the acknowledgement, that's okay. We can rely on that recital. Here's the problem with that title standard. It doesn't actually jive with the code. The notary's role is only one purpose, and that's to verify the identification of the person who signed the document. How am I going to know their marital status? Am I going to ask them for proof? Give me their marriage certificate. No. All I'm doing is I want to see a photo ID. And that's the only inquiry I'm making. So that's why it's yes or no. I think it's poor form to rely on the marital status in a notary section because the reality is no one ever checks the marital status as a notary. And how could you? We want the individual people who are giving that mortgage or signing that deed, we want them to make that recital. Now, if they're lying, then that's fraud. That's another issue. But I don't want to be that the problem being that we didn't ask them for their marital status, and I want that to be on the face of the document, not in the notary or acknowledgement area. Thank you very much for that question. That's a very good question. Yes, ma'am. Yeah, so the question is, a particular lender who will remain unnamed on this videotape sent out a memo saying you're not supposed to change the documents. And again, I have the caveat, it's always good to contact the lender. Hey, would you like us to do that? But I think a lot of times, particularly issues of marital status are being changed on the fly. But thanks for bringing that up, though. Any other comments, questions on marital status? Yes, ma'am. Yeah. So the comment is someone who closes frequently for this unnamed lender that everyone else here closes for too, sure. And so just make the change, have them initial off to the side. So far that hasn't been a huge problem. I will mention too, since we're talking, we sort of mentioned this Wells Fargo versus Hudson case. Another case in its progeny was a case called Ortiz. In that Ortiz case, it was a Spanish speaker, and when they put their recital of the marital status, they indicated the person was a single person. And there's a question in the case whether the person really understood this or not. He was actually separated from his wife. His wife was in Mexico. And in his mind, he was a single person. But you are not single until the court says you're single. Until that decree is issued, you are a married person. So sometimes that creates some situations if the conveyance is happening in the course of a divorce or a mortgage is being given in the course of a divorce. Sometimes we have to have people sign documents in different rooms. Done that many times. Let me talk about power of attorney real quick, and then we'll take a quick break. Powers of attorney are a very common type of instrument that we're using in conveyances. And there was a time, if you had the same amount of gray hair as I have or a little more, where the legal description had to be recited on that power of attorney. And of course, the power of attorney was recorded. And if you didn't have that legal description on there, it was defective. That has not been the law for a long time. So we no longer require the legal description to appear on that power of attorney. If you're drafting a power of attorney for a borrower or in the situation of sale of real estate, my recommendation is you have that power of attorney approved by the lender if it's for a loan situation. Lenders vary in terms of what they want to see in that power of attorney. Some want to see a recital of the loan amount. Some want to see the street address. Some want to have an expiration. This power of attorney is effective only until a certain time. So you probably have sort of a stock power of attorney in your form library, but you don't want to rely on that. Make sure that's done with enough time to get it approved by the lender prior to being used. Otherwise, it'll come back and haunt you. Okay, it's 10:15. We're going to take a little stretch here. We're going to come back in 10 minutes. So in 10 minutes, we'll start up for round 2. So see you in just a few moments. If you have questions, feel free to come up.